Supreme Court of India has underscored that the delay caused by the central government in approving the Supreme Court collegium recommendations is discouraging good, efficient lawyers from giving consent for judgeship. The Supreme Court's collegium system is the process through which judges of the higher judiciary are appointed in the country. The Supreme Court collegium is a 5-member body which is headed by the incumbent Chief Justice of India and also comprises the 4 senior-most judges of the court at that time. While considering a contempt petition filed against the Union Ministry of Law and Justice for not adhering to the timeline set by the court for finishing the appointment process, the Supreme Court discussed how the delay is making many lawyers reluctant to join the bench as they, in the court's words, do not want their life to be dragged into an uncertainty. The Attorney General for India, R. Venkataramani, yesterday submitted a status report before the court which stated that the High Courts are not making the recommendations 6 months in advance for the vacancies, which is leading to the piling up of the vacancies. Addressing this, the Supreme Court bench comprising Justices Sanjay Kishan Kaul, A.S. Oka and Vikram Nath explained the reasons for the inability of the High Courts to make such advance recommendations, highlighting that eminent lawyers are hesitant to take up judgeship due to the prolonged process of appointment and the uncertainty involved. The bench observed in the order, and I quote here, "The main reason is that the window of the age in which these recommendations are made are broadly from 45 to 55 years. Requisite talent of the bar has to be tapped in this age group. There are difficulties in some courts on account of the availability of eligible persons. But more than that, the endeavour is required to persuade the lawyers to join the bench. An elevation to the bench is always considered an honour. However, there has been reluctance on the part of the successful lawyers to accept the honour, and what we have stated in our last order is out of the experience of not being able to persuade such eminent people to join the bench, with one factor largely weighing in with them apart from any other issue, which is the prolonged process of appointment and putting their career on hold. Thus, on one hand, they are making a monetary sacrifice to come onto the bench in a larger cause of justice, but in that process, they do not want their life to be dragged into an uncertainty. The bench also stated that there are instances of persons withdrawing their consent who are recommended to be elevated to the bench. Pertinently, the Supreme Court bench also pointed out that an eminent lawyer withdrew his consent recently as the centre kept his file pending despite being reiterated by the collegium. The bench was actually impliedly referring to senior advocate Aditya Sondhi withdrawing his consent for being elevated as a judge of the Karnataka High Court. However, in the same breath, the bench reiterated that the High Courts must take effective steps to make recommendations in time so that the process of appointments is not stalled. Importantly, the bench also pointed out that the process suggested by the Centre for Appointment of Ad Hoc Judges in High Courts is very cumbersome, and accordingly emphasized that a simpler procedure should be adopted so that the real objective of their appointment does not get defeated. The Supreme Court said that if the cumbersome process suggested by the centre under Article 224A is adopted, then no one is likely to work in such conditions. The rarely used Article 224A of the Constitution deals with the appointment of ad hoc judges in high courts and stipulates that the Chief Justice of a High Court for any state may at any time, with the previous consent of the President, request any person who has held the office of a judge of that court or of any other high court to sit and act as a judge of the high court for that state. Last year, in the month of April, the Apex Court had issued a slew of directions regarding the appointment of ad hoc judges in high courts. It had stipulated 5 trigger points which can activate the process under Article 224A, which are as follows. Number 1, if the vacancies are more than 20% of the sanctioned strength. Number 2, the cases in a particular category are pending for over 5 years. Number 3, more than 10% of the backlog of pending cases are over 5 years old. Number 4, the percentage of the rate of disposal is lower than the institution of the cases, either in a particular subject matter or generally in the court. Number 5, even if there are not many old cases pending, but depending on the jurisdiction, a situation of mounting arrears is likely to arise if the rate of disposal is consistently lower than the rate of filing over a period of a year or more. Accordingly, the bench asked Senior Advocate Mr. Arvind P. Dattar and the Attorney General for India Mr. R. Venkataramani to brainstorm and come up with a less cumbersome process to appoint ad hoc judges in the high courts. Justice Kaul also pointed out yesterday that the ad hoc judges to be appointed to the high courts are not being appointed for the first time. In fact, he pointed out that they have served previously and thus they have the expertise to deal with the heavy workload. In this backdrop, he suggested that the process for their appointment ought to be simpler than regular appointments. Justice Kaul also added that many noted senior lawyers are often not willing to take up permanent judgeship but are inclined to accept the post of ad hoc judge for 2 years and accordingly remarked, and I quote here, "Many eminent lawyers are not willing to join the bench but ready to work as ad hoc judges in some courts and will not practice in that court again." The judge was also critical about delays in making appointments, and he stated that if the appointment is not made within a few days of the recommendation of the Chief Justice of the High Court, then meritorious candidates end up losing interest and that the justice delivery system accordingly faces a huge loss. The bench thus listed the matter for further hearing on 8th of Feb next year and asked the centre to file its suggestions by then, after having a relook at the memorandum of procedure for appointment of ad hoc judges. Thank you. I'm Amaratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.